Welcome back to a weekly webinar series. We are pleased to, of course, announce that today we are talking about a very important topic: offences and penalties under IBC, and the framework of special court. We'll talk about how extensive is the list of offences, penalties prescribed under the IBC, and how these offences and penalties can actually if they are correctly implemented, can actually make IBC a very strong law. So over to Anil sir.
Thank you, Ankit. Thank you very much. So, namaste. Good morning to all the participants. This is our 77th episode of AAA weekly webinar series. In the last episode number 76, we talked about the new procedure for taking over control and custody of the assets and records of the corporate debtor from the corporate debtor. So the corporate debtor also was defined by me, which is like includes promoters, directors, and also all the key managerial personnel who are associated with the information and records and the assets. Now, I also said that it is important that we should start using section 68 and section 70 for the purpose of taking information from the corporate debtor. It is basically a step forward to this, that what are section 68, what is section 70, what is section 72. So therefore, we opted for this subject, that we all must understand what are the offenses under the IBC and what are the punishment and fines prescribed under the IBC, and how can we make best use of this for the purpose of successful resolution and for the purpose of the best realization for the creditors. So our objective only should be to use these sections only to get support, information, record, control, custody from the corporate debtor, and also for the purpose of creating a little bit of fear in the market, that in case any such contravention is done, any such offense is made, then there are courts, efficient courts, and they would take appropriate decision, and there can be imprisonment, or there can be fine, or there can be both. So this is the objective of the today's webinar. So I'll just share my screen and we'll go forward. So friends, deliberations on offenses and penalties, and in fact offenses, and it should be imprisonment and fines prescribed under IBC, and which is the jurisdiction of special courts. So these are the things that we are going to deliberate today: offenses committed by corporate persons, offenses committed by individuals during bankruptcy process. So this is very important that we are writing the bankruptcy process, because the personal insolvency resolution process, which is presently prevailing, and there are about something like 700 applications or 1000 applications pending before adjudicating authority for personal insolvency resolution processes. So there is no offense, there is no imprisonment, there is no fine during this period, the period which is called resolution process. All the offenses, all the imprisonment provisions, all the fine provisions are restricted to bankruptcy process, not the resolution process for individuals. However, for the corporate persons, we have chapter 7. So then in this conversation, we will actually refer to chapter 7 of the code, that actually means section 68 to section 77A. There are total 12 sections. In these 12 sections, starting from section 68 to section 77A, the entire provisions of offenses, imprisonment, and fines are provided. Now then we will also discuss general contravention. There is a section called 235 capital A that provides for general contravention. Anything which is not covered under these 12 sections under chapter 7. So there is a separate section which is provided in the code, which is section 235 capital A. We will also discuss about structure of the special courts under IBC or under the Companies Act, and also landmark judgments so far. So the most important part would be the landmark judgments, which actually would be useful for our audience. Why? Because see, as far as the provisions are concerned, section 68 to 77A, I believe we all can read. How these sections are being used, what is the present prerogative of the IBBI, how the special courts are acting, and what all of us as an insolvency professionals, as lawyers, as committee of creditors should effectively do. That is what is the objective of our today's webinar. So why I'm defining corporate person? Because the corporate person, because this chapter 7 of the code, part 2, because the part 2 is applicable to corporate persons, so therefore it is applicable to all companies, all LLPs, and also any other person incorporated with limited liability under the law, but it shall not be applicable to financial service providers. The offenses which are dealing, which we are in fact trying to deal with, these offenses are again part 2, as I said, section 68 to 77, and then 77A. 77A was freshly inserted only for pre-packaged insolvency resolution process. These are these offenses are regarding concealment of property, regarding transactions defrauding creditors, and regarding the misconduct during the CIRP, and also punishment for falsification of books of the corporate debtor, punishment for willful and material omissions from the statement relating to affairs of the corporate debtor, punishment for false representation to creditors, and then punishment for contravention of moratorium. See, section 74 is also very important, because this is actually, this will deal with two things. One, contravention of moratorium. In this particular section, even the creditors, members of the committee of creditors also can be made responsible for any contravention, and there is a imprisonment prescribed for the committee of creditors also. And also in this section 74, we will also find contravention of the resolution plan, means that in case the resolution plan is not implemented by the successful resolution applicant, so that successful resolution applicant can also be prosecuted under section 74 of the IBC. Then we have the 3 sections. The last 3 sections are basically section 77 is for false information in an application under section 10. Section 76 is the false information under section while making the application under section 9, and section 75 deals with the false information submitted to adjudicating authority under application under section 7. Now, Ankit, we are going ahead with the section by section understanding of the offenses and the non-compliance offenses under the IBC. So first is very, very important, which is section 68, where any officer of the corporate debtor has within the 12 months. Now, the important part is, one is the officer. That officer is defined by the IBC, and this officer includes all the directors and all other key managerial personnel and any persons associated with the management of the company. That is the officer's definition. Has within 12 months immediately preceding the insolvency commencement date. So insolvency commencement date and 12 months behind that. Willfully concealed any property or part of such property of the corporate debtor. Willfully concealed, chupa liya, or concealed any debt due to or from the corporate debtor of the value of 10,000 rupees or more. Any debt, anything which is receivable from someone has been concealed. Debt payable to someone has been concealed. That's an offense. Fraudulently removed any part of the property of the CD of the value of 10,000 or more. Because see, this is very, very normal. We all have experienced that the properties are being removed, and of course it is being removed fraudulently. and the value, of course, is more than 10,000. So the section 66, 68 is applicable in almost all cases wherever we find some kind of efforts from the promoters or the officers of the company to do last minute some kind of diversion. Then willfully concealed, destroyed, mutilated, or falsified any books or papers affecting or relating to the papers of the corporate debtor or its affairs. Now, the clause C talks about the documents and papers. It doesn't talk about the property, it talks about the documents and papers. Now, within this section 68, we have further willfully made any false entry in any books or papers affecting the properties of the corporate debtor or its affairs. So maybe some false entries are made by the officers of the corporate debtor, whereby the assets of the company can be reduced or the liabilities of the company can be increased. Fraudulently parted with or altered or made any omission in the documents or relating to the property, again altering the documents. Willfully created any security interest, like that is also something that we create a security interest on the assets of the corporate debtor with some kind of fraudulent intent. Willfully concealed the knowledge of anyone who has the knowledge of anyone doing all these A to F clauses. That person is also responsible in case he had the knowledge of that somebody is doing this in the company. So this is the section 68, and the section 68 in fact talks about at any time after the insolvency commencement date committed any of the acts mentioned into A to F or has the knowledge. At any time after the insolvency commencement date takes in, pawn or pledge or otherwise received the property knowing it to be secured, transferred or disposed of. So this is also very important. The Roman 3 is very important in case any after the insolvency commencement date, if any property of the company is being pledged or it's being transferred or disposed of by the officer of the company, that is a direct offense. And the punishment in this case shall not be less than 3 years, which may extend to 5 years, and the fine will be between 1 lakh to 1 crore of rupees. But one saving clause is there in all the sections, provided that nothing in the section shall render a person liable of any punishment under this section if he proves that he had no intent to defraud or to conceal the state of affairs of the corporate debtor. So whenever you start any proceedings under these sections, this particular proviso, more or less in all the sections it is available, that nothing contained in this section, although it has to be kind of a intent of defrauding or that concealment, that should be somehow has to be proved, because this is these are the provisions which are criminal allegations, offenses, and in case the cognizance is taken by the courts, then it would end into imprisonment or fine or both. So coming to section 69, normally section 69 and 66 is seen almost one part is civil, the other part is criminal. But see, when we read the section 68, we do not find much similarity in section 66 and 69. Rather, it was very important that today that I actually have seen that section 67 is also very, very relevant. In case, like I believe, Ankit, the audience will definitely have interest in understanding what exactly I am trying to talk. I am saying section 67 immediately after 66. Now, this section says the proceedings under section 6. Section 67 says where the adjudicating authority passes an order under subsection 1 or subsection 2 of section 66, as the case may be, it may give such further directions as it may deem appropriate. So within that order under section 66, the adjudicating authority can also pass an order. Number one, what that order can be: provide for the liability of any person under the order to be a charge on any debt. If there is a liability, under section 66 against any promoter or associate concern or directors or any officers of the company. On the other hand, if the company has any debt payable to that person, within this order of 66, the adjudicating authority can say that this particular order will be a charge on that debt. So that person, even if it's an amount payable to promoters to the extent of 100 crores as an unsecured loan, as a secured loan, or if the amount is payable to the associate companies, may be secured or unsecured, in case there is a Section 6 order which says that this much money has to be taken from the promoters because of the fraudulent transactions, then the order can also say that this amount which is payable to the promoters, associate companies, officers of the company, that would not be payable. There will be a charge on that debt against this recovery. So then whenever we make an application under Section 66, we should also add a prayer that there are some amounts which are payable to promoters, there are some amounts which are payable to the associate concerns, there are some amounts which are payable to the officers of the company, and appropriate directions may be issued when Section 66 orders are passed that those amounts would not be payable and there will be a charge on that. Now, subsection 2 of Section 67 says that where the adjudicating authority has passed an order under subsection 1 or 2 of Section 66, as the case may be, in relation to a person who is a creditor of the corporate debtor. So in case any other person who is a creditor of the corporate debtor, then adjudicating authority can also adjudicate that particular debt. That particular debt will fall in the lowest priority of Section 53. In the lowest priority of Section 53, when all others are paid, then only he will be paid. So that means when in a resolution plan, we normally provide that the unsecured loans from the directors, unsecured loans from the associate concerns or the officers of the corporate debtor will not be paid any amount. We should write, since there are allegations under Section 66, based on the provisions under Section 67, these amounts would not be payable. So these are the prayers that we must add in our Section 66 application after looking into the liabilities of the company, and if there are some liabilities towards promoters, associate concerns, officers of the company, those liabilities should be as lowest priority or amount which is receivable promoters under Section 66, those debt have a charge on that. So first they will pay that, then only they will be able to claim that amount. So this is something which is the new kind of understanding by me, and that is the reason that I wanted to share with all of you that this particular prayer should be added in our application under Section 66. So Ankit, going ahead, should we go ahead, or there is anything else at this moment that we can do?
Go ahead, and maybe we can take some questions after some time. Yeah.
We'll take after some time?
Yeah.
Okay. So then I was on Section 69 when I recalled Section 60, recalled in my mind Section 67. So I said Section 67. Now, in another scenario, we have Section 67A, that is for fraudulent management of the corporate debtor under pre-package insolvency resolution process. But this Section 67 is not to be adjudicated by the special court. The Section 67, for this PPIRP, this will be adjudicated by the Rating Authority, NCLT. So punishment for transactions, they see this is a very different kind of offense. Officer of the corporate debtor or the corporate debtor has made or caused to be made any gift or transfer or charge on, or has caused or connived in execution of a decree or order of property of the corporate debtor. So let us understand the property of the corporate debtor. So the property has been defined in the court, which includes everything, including cash, receivables, trade. Everything has been defined in under the property. So when we say property, it doesn't mean that the property only means the property means real estate, or property means the immovable, or property means movable. The property means everything, whatever we consider as an asset: cash, bank balances, receivables, machine, plant, asset, trademark, brands, everything is commonly called property. So if there is any gift of any property, transfer of any property, creation of charge on any property, or actually execution of a decree of any property, and that is has concealed or removed any part of the property of the corporate debtor within 2 months before the date of any unsatisfied judgment, decree, or order for payment of money obtained against the corporate debtor. So, like, there are some judgments, there are some law where the properties are supposed to be given in case those properties are being transferred. That is what is section 69. And the punishment is, of course, it's like similar. See, like, as far as the punishments are concerned, I would not be speaking after every section what are the punishments. All of us can read it. The punishment varies from 6 months to 5 years, and the fine, which actually varies from 1 lakh to 1 crore, the court can decide. The special court, or in some cases the magistrate, can decide whether it would be a punishment and fine, or only punishment or only fine. Then we actually have to see the trend in those courts. What my understanding is, the trend will define whether what kind of actions are being taken by the special courts against such offenses. Maybe something which is only disposed of by imposing a fine, maybe something which is, because this particular imprisonment which is mentioned in these sections are also the maximum and minimum, but like, then there is a discretion given. There is a discretion of imprisonment or fine, and discretion is or both. So there is a huge discretion on the judge whether it would be what kind of penalty would be imposed. Again, in this section, provided that a person shall not be punished under this subsection if the acts mentioned in clause A were committed more than 5 years before the insolvency commencement date, and if he proves that at the time of commission of those acts he had no intent to defraud the creditors of the corporate debtor. So that is also something which every defendant will try to use in his favor. Again, coming to section 70. So when we are saying that we are using section 68 and 70 and then also 72, these sections are being used that whenever we are filing an application under section 19(2) or under regulation 30, we should take an order, we should take interim orders from the adjudicating authority. Those interim orders must show that the directions were given. When the directions are given, that means that this adjudicating authority prima facie made a case, then only the directions are given. So in these prima facie observations of the adjudicating authority, that would be really helpful. IBBI will file prosecution against this under this section 68, 70 and 72 before the special court against the officers of the corporate debtor. Now, the punishment for misconduct in course of CIRP, again on or after the insolvency commencement date, where officer of the corporate debtor does not disclose to the RP all the details of the property of the CD and details of the transactions thereof, or any such other information as the resolution professional may require, or does not deliver to the RP all or part of the property of the corporate debtor in his control or custody, and which is he is required to deliver. Ankit, when you switch off your video, my picture comes on I think you should log in from your whenever you also create an account in Zoom, where you can actually add your picture, because see, and if you would log in your account, then your picture will appear. Now my picture is appearing when you are switching off the video. Am I audible to you? Okay. So then is the does not deliver to the resolution professionals all books and papers in his control or custody belonging to the corporate debtor which he requires to deliver, fails to inform the resolution professional the information in his knowledge that a debt has been falsely proved or any person during corporate debtor, prevents the production of any books or papers affecting or relating to the property or affairs of the corporate debtor, accounts for any part of the property of the corporate debtor by fictitious losses or expenses. So these are all something which is required to be complied with by the officers of the corporate debtor during CIRP, and the imprisonment is mentioned. And also there is a proviso that nothing in this section shall render a person liable to any punishment under this section if he proves that he had no intent to do so in relation to the state of affairs of the corporate debtor. So these are the two sections which we are now using regularly for the purpose of seeking information from the officers of the corporate debtor. Now coming to this punishment for insolvency professionals if she deliberately contravenes section 70 subsection A. Section 70 subsection 2 provides that if the insolvency professional deliberately contravenes the provisions of this section, this part means part 2. Part 2 basically is the resolution process and liquidation process of the corporate debtors, of the corporate persons. So the RP also can be prosecuted under this section, and there is an imprisonment which is prescribed for the RP, which may extend to 6 months, or a fine, and the fine can be between 1 lakh to 5 lakhs rupees. So then we move on to section 71, punishment for falsification of books of account on or after the insolvency commencement date, where any person destroys, mutilate, alters, falsify any books, papers, securities, and makes it in the knowledge. So this is again like kind of a modification, falsification of books of account, and there is a punishment under section 71 also, that is on and after the. Then punishment for willful and material omission from the statement relating to the affairs of the corporate debtor. Again, this is an information that has to be provided to the RP. This also can be used. Where an officer of the corporate debtor makes any material and willful omission in any statement relating to the affairs of the corporate debtor. So whenever we are filing an application, so we can use section 68, section 70 and 72, because these three sections are basically for seeking information, records, and custody and control from the officers of the corporate debtor. So because I'm using the word officer because the officer has been defined, and officer, and then when we are using the word as property, that means the property has been defined. So these words are having larger meanings. So therefore, I can't use the word promoters. I would use the word officers as defined. I would use the word property as defined. That means it includes everything. It even includes those officers, those persons who are associated with the management of the company. Now, the false representation to creditors. Now, this when the code was made, it was also made with the intent that most of the resolutions will be found by taking a resolution plan from the promoters, and section 29A came later. So therefore, the section 73 says that if any decision is taken from the creditors and by false representation, that is also an offense, and there is an imprisonment which is prescribed for this offense. And now coming to the section 74. So this is again very important that I said contravention of moratorium. So this subsection 1 says that the corporate debtor or any of its officer violates the provision of section 14. Any such officer who knowingly or willfully committed or authorized or permitted such contravention, there is a imprisonment for the 5 years. And then like subsection 2 says when any creditor violates the provision of section 14. So like during moratorium, if any creditor recovers any money or any violation of the section 14, section 74 can be triggered, and the creditor also can be prosecuted. Then the subsection 3 says where the corporate debtor, any of its officer or creditors, or any person on whom approved resolution plan is binding under section 31 knowingly and willfully contravenes any of the terms of such resolution plan. So under this section, the prosecutions have been done by the IBBI. Like any person who actually submits a resolution plan, gets approval from the COC, gets approval from the adjudicating authority, and after that, if it is not implemented, that is being covered under any person. So section 74 is being used by IBBI for prosecuting those people who are contravening the approved resolution plans. So there is an imprisonment for 1 year, and which actually can be extended to 5 years, and the fine between 1 lakh to 1 crore of rupees. Now coming to the next three sections, where the false information or non-disclosure of disputes, etc., is provided, like section 75 says that in a section 7 application, if the false information is provided, then the applicant can be imprisoned or it can be fined. So the such person shall be punishable with a fine. So in section 75, there is no imprisonment. It is only a fine. Similarly, in section 9, where the operational creditor do not disclose the dispute between the creditors, and that also is considered to be an offense, and there is an imprisonment for this. Similarly, under section 10, when the application is being made by the corporate debtor or any person who is willingly, that is also a kind of imprisonment. So these three sections are basically that we have dealt with. Section 77A is only and only for the pre-packaged insolvency resolution process. Now we will go to different scenario. So we have discussed section 68, section 67 to section 77A, and we also have discussed that section 68, 70, and 72 can be used for seeking information from the promoters. Section 70, section 74 is for the contravention of moratorium and contravention of resolution plan. So these are the important sections. So far, the prosecutions have been launched by IBBI against all these sections, and there are many prosecutions which has been launched by IBBI before the special courts. Ankit, at this moment we can take some questions, and then we will move on to the special courts, and then we will go to the judgments which has been searched by our research team.
So first question is from Mrinal Gunjal, Mr. Mrinal Gunjan. And the question is that in case a CD had entered into a transaction which the RP classified as section 68 offense, and the property as an onerous property, what will be the implication? So my understanding is that if the property is an onerous property, or rather the property has kind of leads to some kind of liabilities rather than giving any asset or giving any value, then it would not really be beneficial to the CD's interest to kind of have that property back or either deal with 68 there.
So, like, I think I couldn't understand why the RP will proceed under section 69, and that too for an onerous property. Like, what is the question that the RP proceeded against section 68?
It talks about the CD had entered into a transaction for an onerous property. So there, I believe that the RP, if the RP classifies it as a 68 offense, then that would not be, based on the complete due diligence over the idea that the property is an onerous property. Because based on an onerous property, how can we say that there is a diversion through the property sale?
So property is a property, whether it is difficult to realize or not, of course, is a later issue. First of all, we have to see whether there is a fraudulent intent or not by doing this transaction, whether any property.
So fraudulent intent is difficult to prove, especially when a property is kind of onerous property. So in that case, establishing that there's a fraud would also be difficult. So then next question is that under section 70, whether RP has to first approach NCLT or he can directly request IBBI to after 19-2 order is passed.
So this is the where I in fact have my research team and myself, we worked on it, and we sought some information from IBBI also. Now the IBBI says that when you file section 19(2) application, and that section 92 application is not yet disposed of, and in the interim orders passed during this continuation of 19(2) orders also, there is nothing which is conclusive written by the adjudicating authority. Then in case the IBBI immediately files a prosecution under section 68 before the special court, then there is a possibility that in the very next hearing under section 19(2), the promoters, the officers of the company will provide that information, and then the prosecution application will be failed. So therefore, IBBI says that they would go for the section 68 offense when there is something which is conclusive. So in our prayer, whenever we something like 19(2) application, and whenever we argue, we should actually say that some observation should be made whether an offense has actually been committed under section 68 or not, prima facie. Or like in some cases, but the cases that we have found, in some cases the special court has held in this manner that the directions were given by the adjudicating authority, even the bailable warrants were also issued, the information was still not provided. Therefore, the court is taking an cognizance. Therefore, the court is taking a cognizance of offense under section 68, 70, and other sections. Now, the process is when the special court takes the cognizance, that is the beginning of the trial. Then the IRPC, that process will start, like the evidences and the cross examination, and then the final order where the imprisonment or fine would be ordered. So presently, in most of the cases, the special courts have reached only to the first stage, and that first stage is recording that the court has taken the cognizance of the offense under section so and so. So the cognizance is very important under the criminal litigation. Like cognizance is like a charge sheet. So when an investigating agency files a charge sheet, similarly, when the court takes the cognizance, these are two the same thing. So then after this first stage, then the trial starts. This is what is my understanding. If there is any experienced person having experience in criminal litigation, we can give an opportunity to him to speak, so that we would like to understand the cognizance. Does really cognizance mean charge sheet? And also, what is the normal procedure after the cognizance is recorded in an interim order by special court? If there is anyone who has that kind of extreme experience, he can raise hand, and we will take him to the for the benefit of our audience. Any other question, Ankit?
Yep. So next question is from Mr. Arun Kumar Srivastava. He's asking if there is a compounding provision for offences and penalties under IBC code.
There are no compounding provisions under the IBC code. The only provisions are imprisonment or fine or both. So there are no compounding provisions. However, I feel that if there are general provisions under the CRPC, then those provisions will apply, because the Indian Penal Code will apply to this trial. That is what is written in section 236 of the IBC.
Right. So then whenever there is criminal law, there is a concept called mens rea, that there has to be an intention of, doing a crime. So the question is that the proviso to Section 68, it's more like a comment, is that the proviso to Section 68 is more like establishing mens rea to commission of the offense. So
Yeah.
I believe we will find, similar provisions everywhere in the entire offenses provisions, because then when we talk about criminal offenses, then that's something that is important.
So imprisonment, of course, definitely mens rea has to be proved, and the intent has to be proved. And if there is no intent, and still there has been some kind of violation or some kind of offense without the intent, I think the courts are generally taking a very, very lenient view about it.
So there's a comment from Lalit Maheshwari ji with respect to that how if a creditor kind of takes money directly from the debtor by giving some kind of threatening action. So banks can always threaten an action which is legally possible. So I don't see there is a problem with banks taking an action under SARFAESI or IBC, or any creditor attempting to take an action on some kind of a of some borrower. So that's something that can't be said to be illegal, because there seems to be genuine money due. What is illegal is, of course, doing some kind of illegal activity, or rather, forcing somebody illegally to pay money. And I think we have provisions under RBI, and we understand that there are sufficient safeguards to not allow any criminal activities to go on with respect to bank recovery mechanisms.
I believe, Ankit, I believe that the contravention of moratorium, contravention of Section 14 is an
Hmm.
offense.
Hmm.
By whatever means that particular section is contravened, it will be a offense, even if forcefully or even if misrepresentation. But if the creditors recover money during moratorium, it will be an offense, and that will be an offense under Section 74, and that, of course, the cognizance can be taken by the special courts.
But then that money can be recovered from the guarantors, right? That is not under
Like the
moratorium.
guarantors are not corporate persons.
So moratorium will continue only for the CD's interest and the CD's debtors and the CD's
Yes,
money. But
yes.
yes, when we say that because this comment was more of the idea that the bank then started procedures against the guarantors and asked for recovery based on that. So that is something that is not illegal.
Yeah.
So, of course, question from Mr. Srinivas ji asking that can NCLT and CLAT give punishment in IBC, or we have to approach special court? As we discussed,
No NCLAT can give punishment other than Section 235A. Section 235A is a kind of residual section, and in that section, I will again present it before all of you. Section 235, and that section, which is punishment where no specific penalty or punishment is provided. If any person contravenes any of the provisions of this code or rules or regulations made therein, for which no penalty or punishment is provided in this code, such person shall be punishable with a fine which shall not be less than 1 lakh, but which may be extended to 2 crores of rupees. This is the section which is within the jurisdiction of NCLT or NCLAT. So therefore, this kind of penalty can be imposed. But otherwise, the very next section is 236. We will come to 236 right away. But this particular section 235 capital A is within the jurisdiction of NCLT and NCLAT. Yes, Ankit.
so that's about it. We are done with the questions. We can continue now.
So, like we have seen the corporate persons, all this chapter 7 of part 2. Part 2 means the resolution processes and the liquidation processes of the corporate persons. Then we talk about the individuals. Now, the individuals is basically part 3. Part 3 of the code deals with the individuals and partnership firms, bankruptcy, and resolution process. Section 186 Section 186 to 187 deals with all kind of offenses and all kinds of imprisonments, fines, or other penalties. So we are not going section by section for individuals. Only one thing that we are saying, all these sections are either applicable to other than bankrupt. Because see, when we are saying a person who is an insolvent, there is insolvent means a resolution process has started, so that person is not a bankrupt. So all these section 186 applicable on bankrupt, not on the person against whom a resolution process under personal insolvency resolution process has actually is proceeded against. So only when the bankruptcy start, these will start. Only on the bankruptcy, not on during the resolution process. So presently, whatever 1000 resolution processes are going on, all these section like section 186, 180, section 187 are not applicable. So all these individuals are not really prone to any kind of offenses, any kind of imprisonment, or any kind of fine. So we are not presently in today's meeting. We are just giving a general kind of understanding that all these offenses will commence only when the bankruptcy will start, and not while the present scenario is going on, where this is called insolvency resolution process. During this process, there is no offense which can lead to a prosecution, imprisonment, or fine. We have already discussed section 235A, which I said it is within the jurisdiction of adjudicating authority. That we have already read. Now let us talk about the special courts. The special court under IBC and its powers and procedures. The special courts, in fact, was constituted to actually give some relief to magistrate courts. Section 435 was inserted in the Companies Act, where the special courts were designated for the offenses under the Companies Act. Then Insolvency and Bankruptcy Code came, and these special courts were also given powers under the Insolvency and Bankruptcy Code, and some further amendments were also made. So section 236 of the IBC provides that all the offenses under the IBC shall be tried by a special court established under Chapter 28, Section 435 to Section 446 of the Companies Act 2013. In fact, what my understanding is, there are more than 26 special courts have already been established in India, and the cases are actually, the only objective was to speedy disposal of these cases. Now let us understand what exactly Section 236 says. 236 of the IBC, which says that notwithstanding anything in the Code of Criminal Procedure 1973, offences under this code shall be tried by a special court established under Chapter 28 of the Companies Act. So the Chapter 28 is a special chapter which actually comprises of Section 435 to 446, where the special courts are established. And CRPC is the Code of Criminal Code, and that actually the trial would be done under the, but then as subsection 2 says, no court shall take cognizance of any offense punishable under this act save on a complaint made by board means IBBI, or the central government, or any person authorized by the central government in this behalf. So presently, either the Ministry of Corporate Affairs, which is central government, can do that, or any other powers which can be delegated by the ministry, central government, or the IBBI. So presently, IBBI is empowered to take any cognizance of any offense on a complaint. So who will make a complaint? The complaint will be made. The complaint will be made by the IBBI. Now, the provisions of Code of Criminal Procedure 1973 shall apply to the proceedings before a special court for the purpose of said provisions. The special court shall be deemed to be a court of session, and the person conducting a prosecution before the special court shall be deemed to be a public prosecutor. Then the section 236 further says that notwithstanding anything contained in the Code of Criminal Procedure, in case of a complaint under subsection 2, the presence of the person authorized by the central government or the IBBI before the court trying the offences shall not be necessary unless the court requires his personal attendance at the trial. So once the IBBI files a complaint before the special court, it is not necessary for the IBBI to present before the court always during the proceedings. The court shall take cognizance of the offence only after the complaint is being made in writing by the board in the offences relating to insolvency and bankruptcy. Special court shall be deemed to be the court of session. So that's what is the scenario. So there are powers of the special courts which are given, and these powers are all powers of session court. So there has been a dispute. There has been a dispute regarding the powers of the special court and powers of the magistrate court. Now, some part of it we have seen, because see the special courts under IBC, its powers, we have seen in section 435 their purpose, their composition, their qualification, which I don't think that we will get time. So I have to go to the judgments so far, because this is what my audience would like to see, the judgments so far. So this what are the offences triable by the special court, section 436. All this is presently we are not conducting summary of the trial by, because this is also summary of the trial by special courts, and there are some kind of disputes regarding the anything which is for which an imprisonment of more than 2 years are provided, the special courts are having the jurisdiction, and any offense where the imprisonment of less than 2 years is provided, for that it is the magistrate would be having the relevant authority. So this is where I want to just tell you this. Now, then we actually have to go to the High Court judgment. The landmark judgment in this case has come from the Bombay High Court, which is in the case of Satyanarayan Bankatlal Malu versus IBBI, because the IBBI is a applicant in this case probably, and the complaint is against Satyanarayan. And in this particular case, the Satyanarayan Bankatlal Malu in fact went to Mumbai High Court, and the issue was whether the additional session judge does not have jurisdiction to entertain the complaint filed by IBBI for an offence under IBC. But the petitioner says that the pressed on the view that the session judge did not have jurisdiction to entertain IBBI's complaint while relying on section 236 and 435 of the Companies Act. Though IBC came into effect, special courts comprising of session or additional session judge were established to try offences under the Companies Act, which were punishable with imprisonment with 2 years or more. As such, only one class of special courts was established, that is the court comprising of judge holding office of the session or additional session judge. So in this case, what he was trying to say, the special courts were only having jurisdiction for only up to more than 2 years of the imprisonment. Then he was saying that only one kind of court was established, special courts. So there is no second court which has actually been established so far. Second court means any kind of offense where the imprisonment is less than 2 years, that particular court has not yet established. Therefore, since the cognizance is not being taken, I'm not sure whether the 2 years or less. So this is the kind of dispute which came before the Bombay High Court. And the respondent also said something, and the Bombay High Court also observed something. And finally, it was held that the offences under the Companies Act punishable with imprisonment for not less than 2 years, courts of metropolitan magistrate or judicial magistrate first class were empowered to try such offences, but this class of court were not special courts. So after the IBBI, which came on effect on 1st December 2016, once again, Companies Act was amended with effect on 7th May 2018. By this amendment, for the first time, legislature designated the Court of Metropolitan Magistrate and Judicial Magistrate first class as special courts to try the offences in the case of issue process under the sections. Now, the proceedings in this case was the the judicial, with this particular judgment finally said that the special courts were empowered to take the this kind of offences, and the issue processes, like anything which is the less than 2 years, which is called issue process, there the metropolitan magistrate would be the adjudicating court in such manners. See, we have some important judgments from NCLAT, Appellate Authority. These judgments, in fact, are something which we all need to understand, because there is a procedure which is defined in these judgments. And this is like the Lagrapati Ramesh versus Mrs. Ramanathan Bhuvneshwari. This is the NCLT judgment, and this judgment says whether the adjudicating authority is competent to direct the investigation straightway, which is to be conducted by the SFIO, Serious Fraud Investigation Office, under Section 69 of the Code. Now, the brief facts: the CIRP against Bona Infra Project Private Limited was initiated, and Section 68, read with Section 25(2), 69, 70, and other application sections, the applications were filed. Section 69 prescribed punishment for transactions defrauding the creditors by an officer and the promoters of the corporate debtor. The facts in this case was that during CIRP, if the officer or the promoter of the corporate debtor does not disclose to RP all the details of the property, etc., application was opposed by Sanjay Raj, one of the promoters, on the ground that the application was not maintainable either on law or on facts. It was denied that the company was a shell company and asserted that the applicant is a New Age Properties LLP and is not a group company. The adjudicating authority, in exercise of the power conferred under Section 213 of the Companies Act, made following observation and given following directions in the result. By exercising powers conferred on this adjudicating authority, which being NCLT under Section 213 of the Companies Act, the IA number so and so is disposed of. Now, the disposed of means the contentions. Let us try to understand the contentions of the applicant. The adjudicating authority cannot act as a special court. That, of course, is their right of contention. The adjudicating authority erred in passing order under Section 68, 69 of the IB Code. Section 212 of the Companies Act can only be invoked by the central government and not by the adjudicating authority. Adjudicating authority cannot refer the matter directly to SFIO. So this was the applicant. This is a case before the appellate authority. Now, the respondent said before the appellate authority that no assets or no record or assets of the corporate debtor has been handed over till date, and the application under Section 7 was admitted on 17th of 18. Different activities of the promoters, including fraud committed by them by diverting funds to the group companies, having come to light through other records and accounting systems. No prayer was made for investigating and punishment in terms of Section 66 or Section 69. You see, like the respondent, like the RP, say that I've never made a kind of I have never made a prayer for 69 or for referring the matter to. Now, the observation of the NCLAT in this case was that from bare perusal of Section 212 of the Companies Act, the 212 actually deals with the investigating into the affairs of the company. 212 deals with when it is to be referred to SFIO. 213 of the Companies Act deals with the investigating into the affairs of the company when it is not being referred to SFIO. Now, Section 212 says that it will be evident that such investigation in the affairs of the company can be made only on receipt of a report of registrar or inspector under Section 208, or on intimation of a special resolution passed by a company that its affairs are being regulated, are required to be investigated. NCLT is the adjudicating authority under Part 2 of the Code and not a special court as per Section 236. Adjudicating authority was not competent to straightaway direct any investigation to be conducted by the SFIO. However, the adjudicating authority being competent to pass order under section 213. Now, the judgment finally says, that the investigation by SFIO cannot be directed by NCLT. Adjudicating authority has wrongly ordered for SFIO to conduct investigation into the affairs of CD. Now, the matter requires investigation to find out whether one or other promoter or the company has violated any of the provisions of section 68, 69, 70, 71, 72, 73. We modify the impugned order dated 16th of April 2019 and refer the matter to Secretary, Ministry of Corporate Affairs, Government of India, to get the matter investigated by inspectors or inspectors. If actionable materials making out a case of fraud is made out after such investigation by the SFIO, it may act in terms of subsection 2 of section 236 of the IB code. So that is what is the modification done by the NCLAT in this order. So we can conclude adjudicating authority cannot directly refer the case to SFIO. They can only register a cognizance. They can say that some prima facie evidences have been found of offenses under section 68, 69, 70, 71, 72, 73, and the matter may be referred to the Secretary, Ministry of Corporate Affairs for appointment of inspector or inspectors. And those inspectors will function under section 208 of the Companies Act, and section 213 can be used for investigating into the affairs of the company. So this is what is the ultimate conclusion of this particular judgment of the appellate authority, NCLAT. Now there is another judgment of NCLT, Ankit, and another judgment says that the issue whether the adjudicating authority or the RP can initiate the prosecution under section 7. But the appellant says that the authority that there was no occasion to issue such any direction for initiating prosecution by RP, that a police complaint has been filed by the resolution professional before the police station. So these are the two things that has been actually the appellant, the promoters or any officer of the company has gone to the NCLAT saying that the RP has no power, and RP has also filed a police complaint before Kalkaji police station. The respondent, means the RP, says that with regard to offences under section 70, RP has given the information to IBBI. RP has not proceeded against any person. Whereas IBBI will do that. As far as the police station report before Kalkaji police is, that has got nothing to do with the fraudulent transactions under section 66 or 69. That is for the offences other than these offences. Now the NCLAT, what it says? NCLAT says the one that the prosecution under section 70 has to be on a complaint filed by the IBBI. The appellate authority thus clarified that any prosecution under section 70 can be initiated only under section 236. That procedure has to be adopted. Then it is very important that the NCLAT said, with regard to any other offences, including the offences under Indian Penal Code, if any complaint is filed by the RP before the police station, that is a completely separate issue and has no concern with the offences under section 70, and the order impugned shall have no bearing on such proceedings at the police station. The police station is independently investigating whether there is any offence under the Indian Penal Code or not. That is what is the judgment of NCLAT. Now, is there any question at this moment, Ankit? Because the time is short and I want to just cover these judgments.
I think you've already answered one question, which was about how to file these applications. You've already talked about that in the judgment. You can continue and then maybe we can, we are anyways over the time limit.
See, again, I'm saying that this NCLT judgments again say that the adjudicating authority is having no jurisdiction to directly refer the matter to SFIO. That's again NCLAT Delhi judgment. And then we are saying the NCLT orders. NCLT orders are saying 𝐝𝐤𝐬𝐬𝐜𝐝 says whether the adjudicating authority has the jurisdiction to register a criminal complaint under the provisions of IBC, whether the adjudicating authority can hold a preliminary inquiry into the offences under section 191, 192, 193, etc., of the Indian Penal Code, or direct the chief monetary position to hold such inquiry. So the observations of the court was that it can only be tried by special courts established under Chapter 28 of the Companies Act. Section 236 has been provided in the code, and it is clear that the adjudicating authority is not a special court. So if it is not a special court, that means all these questions are answered in negative. Then the special courts, we have found the special courts orders also. Special court Dwarka, in the case of IBC versus Intendrapal Singh, it says, finally, it has what is held in this case. As per the provisions contained in section 236 of the code, the complainant, that is IBBI, has the power to set the criminal law into motion through its authorized officer. That is the special court set up in Dwarka. After considering the documentary evidences placed on record, the court was satisfied of the offence prima facie committed. Hence, the cognizance was taken, and the accused person were held liable for offences under Section 68, subsection 1, clause B, Section 70, subsection 1, clause C, Section 74, and Section 19.1 read with Section 235A of the code. I'm not sure why Section 235A actually has been used here, because see, the 235A is not Chapter 7. It is outside Chapter 7. So whatever 236 is applying only on Chapter 7. So Section 235A is the power with the adjudicating authority. 230A is excluded from Chapter 7. So therefore, my understanding is that under Section 235A, the adjudicating authority can directly impose penalty to the extent of 2 crores to a person. IBBI versus Sandeep Singh Madok. I'm not going to facts because of the shortage of time. I'm only saying that this is again an order from Special Court Dwarka, relying on the notification number 2554, where the special courts have been conferred with the jurisdiction to try on offences in the capacity as a special court under Section 435 of the Companies Act. After considering the documentary evidences placed on record, the court was satisfied of the offence prima facie committed. Hence, the cognizance was taken, and accused person were held liable for offences under Section also. So when the cognizance is taken, as I have already said, the cognizance is just like a charge sheet. After this, as per the Indian Penal Code, as per the Criminal Procedure Code, this would be now tried. There will be a cross-examination, but then there can be summary also. Now, coming to the after the special court, we actually can have another special court Dwarka order, and that again is like cognizance is being recorded. That is against Karan Chandana. Again, we have another order where the key managerial personnel were also considered as the accused, and the cognizance was recorded against them. So this is all, Ankit, like, see, what I wanted to say, that cognizance has been recorded in many cases by special courts. As what we are supposed to do, we should use Section 68, 70, 72. Our objective should not be to harass anyone. Our objective should be to take information, record, control, and custody on the assets and information of the company. The objective should be to maximize the valuation, to maximize the recovery, and to make the company finally successfully resolved and turned around. That should be the objective. However, in Section 19.2 application, in an application under Regulation 30 of the CIRP regulation, we should pray before the adjudicating authority that there should be some order passed. Maybe there should be some record that yes, there is an offense by the promoters, by the officers of the corporate debtor. Yes, there is an information which is not being given. So that kind of recording will finally help in getting the cognizance recorded by the special courts. So anything that, Ankit, we can take as a question?
One last question that we can take, that does the special court has the power to grant bail?
So detention is only provided within not more than 15 days detention, in case the court see that this kind of detention is required. So why detention is normally ordered so that the person is not doesn't try to kind of erase the evidences. I don't think that the detention would be the outcome in any cases. It will be the final order that will be the only scenario. And final order, whenever it comes from the special court, that will go for appeal before the High Court or before the senior court. So if any question is there, so I can actually pick up now.
No, sounds good. So I believe we have no other questions that is now left out. So we can, I think this is a very, very good input that using these sections, something we should do actively so that wherever we have some issue, we can take it up. So great. And thank you, participants, for coming and attending this webinar as always. And we will again have the next webinar next week
Thank you
at the
very much.
scheduled
Thanks a
time.
lot.
Thank you, everyone. Thank you.